Hi, everyone. Harry here to talk about a new motion from James Comey to dismiss the indictment for false statement and a related offense for the reason that the question from Senator Cruz that he answered purportedly in a false way was completely ambiguous, a 3-minute sort of word salad that one could not have understood and much less know the construction that would make the statement false, his response. And moreover, his statement, in fact, is not false, cannot be false, because he presciently and on his feet gave the answer, I stand by my previous testimony. And even if you wanted to say, and he insists in the motion, it wouldn't be true. His previous testimony was, in fact, true. But even if you wanted to say it was false, saying, I stand by my testimony is itself literally true. And you can't bring a false statement charge when the actual statement is literally true. Okay, you may remember when the Comey indictment came down, I was really focused on it and thought it was a big and terrible development. And I wrote 5 Substacks that week, got a little out of control. But one of them said precisely this, identified as the second and third kind of claim he might make. 1, it's literally true. And 2, it's just too ambiguous what Cruz said to even ground a false statement prosecution. So indeed, there we have it. Now, recall the first 2 motions to dismiss. They were and are, they're pending because it's a vindictive or selective prosecution against him that the government has brought. Basically, Trump just commands to go after Comey because he regards Comey as an enemy and political opponent. And then second, that Lindsay Halligan was improperly appointed, and that motion, copycats of which are being played out in other districts, and Tish James has also brought about Halligan, is especially potent potentially for Comey because, recall, his indictment occurs at the very end of the statute of limitations. So it may well be that if the judge, and it's a recused judge in another district, not the one that the rest of the case is in front of, that's just because it could be an appearance of a conflict that he would sit on this and then hear day in, day out, as all district judges in that district do, representatives from the very office that he might disqualify the U.S. attorney for. Those bases are really sort of classic motions to dismiss because they don't turn in any way on the words in the indictment, the allegations in the indictment, etc. This one's pretty similar, but it seems to me it's not as clean as a motion to dismiss at the outset before any discovery or any evidence has been taken. And that's because, in particular, the statement, I stand by my testimony, it seems like it's got to be true, 99% true. But to really establish that it's true, do you need to hear from Comey saying, here's what I meant, here's what it was, and here's why it was true? You can imagine a situation where the actual words he says, I stand by my testimony, are false. So it's very far-fetched to say he doesn't really stand by his testimony, or he's got his fingers crossed behind his back. But that's the reason you might have expected this to come a little later. But I think it's perfectly proper and understandable. So Judge Nachmanoff now will look at the statement that the 3-minute kind of rambling diatribe from Cruz that gave rise to Comey's. I stand by my testimony, and also will judge as a matter of law, but it does have a little bit of an alloy of facts as well, whether the statement, I stand by my testimony, is literally true and therefore can't ground properly a false statement prosecution. Okay, so let's talk just a little bit more about his argument and go through the motion. And so he leads with this point that nobody could even understand. And remember, we're talking criminal law doctrines, guilty beyond a reasonable doubt, etc. But basically, Cruz, just as Cruz will, goes on for more than a minute. And let me give you a little bit more of the flavor. It's set out, but he says, now, on May 3rd, 2017, in this committee, Chairman Grassley asked you. He then asked you this. You said no. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal, and you were aware. Now, what Mr. McCabe is saying and what you testified, one or the other is false. Who's telling the truth? Put yourself now in Comey's shoes and try to discern what exactly is he saying. There seems to be something about, did I, Comey, know at the time what McCabe did? Although McCabe says that it was proper anyway, and I had the whole testimony. And Comey gives a really clean, good answer here. That may in fact save the day, though I don't think there's really any prospect that he's ever going to be convicted. But he says, I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017. So your testimony, Cruz pounces, is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. So he tries to, actually boil it down a little. Comey doesn't take the bait, just says flat out, again, I'm not going to characterize Andy's testimony, but mine is the same today. So you, go through that and hold it up against the indictment, which very tellingly doesn't even lay out the statement, right? Both the Comey and the James indictments are just, completely unprofessional, below entry level kinds of documents. Not even bare bones. So he has every right to be saying, what are you talking about? Who's person one? Who's person three, etc. And here's what they actually say in the indictment. You would always, in a false statement indictment, have, and this is no brilliant insight on my part, have the goddamn false statement. Here's what this indictment says. On or about September 30th, James Comey did willfully and knowingly make a materially false, fictitious, and fraudulent statement. This is the point where the template that even as a junior prosecutor, you get out and try to copy says, to wit, I have never said, whatever the false statement is, it's glaringly missing here. He made a false statement in a matter within the jurisdiction of the legislative branch, and then it characterizes it this way. By falsely stating to a U.S. senator that he had not, quote, authorized someone else at the FBI to be an anonymous source in news reports. Whoa. What's between quotation marks? Comey's statement that's ostensibly false? No. The best sort of kernel that they're trying to clarify of Cruz's statement, which Comey doesn't directly respond to and just says, see my statement back in 2017. Okay, so that's really telling that they don't even say the statement that they say was false. And that's his lead here. And then there's law that says when an answer to a fundamentally ambiguous question may not, as a matter of law, form the basis for a false statement. And that's well established. You can't just, serve up some cloud or word salad, as I've said, and then say, aha, here's what I meant. So I'm going to use that to interpret what you meant. And that's false. No. False statement beyond a reasonable doubt. It damn better, for starters, be false. And then we would get to willfully and all the other stuff. Okay, so that's the big first submission. And by the way, that's just the immediate Cruz words before the question. The whole thing is a Senate rambling kind of set of sinister suggestions that really leave a reasonable witness, I think, scratching his head. Okay, so, it's not clear what he's going for, and that you can't, it's actually a violation of the due process clause to convict on that basis. And then second, his answer is literally true. So you've got to dismiss for that reason, where a witness's answer is, quote, not responsive to the question asked. That's not exactly what he's arguing here, but it can't be the basis for a false statements charge. And this is basically what's known in defamation or false statement law as the literal truth defense. It's a narrow one. It's got to be, on its face, literally true. And that's one reason I said that a court might say, I need to take a little evidence to really be sure here. But in any event, I stand by my testimony is literally true. And remember, we're talking about something that happened many years before, and then he made this I stand by it statement 5 years ago. So it's so remote anyway, and there are problems of whether anybody could care about it. That's materiality. That might be a preview of coming attractions. But the second big point is, this is literally true. I do stand by my testimony. I also, dropping a footnote, say that testimony was true then and is true now. But regardless of the truth of that statement, the statement, I stand by my testimony, is literally true. So you can't get me for that. Okay, so we now have 4 basically arguments that he served up. The improper appointment goes to one judge, and the other 3, selective prosecution, totally ambiguous, and literal truth, are now in front of Nachmanoff. We'll see how the government responds. Perhaps Nachmanoff will try to handle all of these at the next hearing, which is scheduled for November 19th. I'm actually hopeful that I can attend it in person. We will see. But in any event, Comey has now fired back 4 pretty powerful shots against what is a really lousy, threadbare, and completely vengeance-driven indictment, and one that ought to be dismissed for any of several reasons. And if it weren't by any chance, should be the subject of quick work by a jury finding acquittal. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.